Good afternoon, competitors, family, and friends. Welcome to the 35th Annual Charles W. Froessel Moot Court Competition. I'm just going to introduce Ian Thomas, the Chair of the Moot Court Association, for the Chair's remarks.
Thank you, everybody. Welcome to the 35th Annual Charles W. Froessel Final Round. I want to start off by just sending my warmest congratulations to both the final round competitors and all the competitors and new members of the Moot Court Association. Please give yourself a round of applause. I'm going to run through a list of thank yous right now, so bear with me because a lot went into this competition. I'm going to start off with Dean Matisar. He's been constantly supportive of the Moot Court Association, and we appreciate his continued support. Additionally, I want to thank Professor Abraham, our faculty advisor. This competition couldn't have happened without her. She has been constantly supportive of both myself, Joanna Wine, our vice chair, Harley Tenson and Avraham Bask, our authors, and the rest of the e-board. And it's been a pleasure working with her, and we hope for the continued support. I'd also like to extend a thank you to our final round bench. You'll be hearing a little bit about them momentarily, but needless to say, we really appreciate having such distinguished attorneys and members of the legal field taking the time out of their busy schedules to come sit down here and help mold the future of the legal profession. And for that, we greatly appreciate all their help. Also, I'd like to thank all the other judges that helped out during this competition. From what I saw, they were giving you guys some pretty tough questions and keeping you on your toes. You guys all did a hell of a job, standing pat and doing what you do best. I actually see a few judges in the room right now, but the Moot Court Association extends a heartfelt thank you for all the help that we've received from outside attorneys, alumni, professors, members of the Moot Court Association in helping judge these rounds and make sure that we have strong new membership in the Moot Court Association. I'm now going to get to specific Moot Court Association thank yous. I first want to thank generally the members. I was expecting to have some trouble getting help from there's just the regular members of the association, but every single member has really stepped up and done their part and more to help ensure that this competition went almost flawlessly. And for that, I personally appreciate it. I know Gaurav and Stephanie personally appreciate it as well. And I'd like to give all the Moot Court members a quick round of applause for all the help. Specifically, I'd like to start off by thanking Harley Tenson and Avraham Bask, the authors of the Froessel fact pattern. Watching many of you tangle with the issues that they put into that fact pattern over the past 4 or 5 days has been somewhat of a sadistic pleasure of mine, but you guys have done a hell of a job. They did a hell of a job writing a fact pattern, and for all the work that you guys put into writing your brief and preparing oral arguments, I can tell you that watching the two of them from, I guess, the end of April on through basically up until today, their work ethic is incredible, and it's really a testament to the type of people they are, and I'd like to give them all a round of applause for their hard work. And I can't thank the authors without thanking the editors, Christopher Binns and Daniel Costello as well. Let me tell you, they both have completely different styles. Chris is sort of silent, confident, and gets things done. And Danny is in your face. I want to make sure everything's going right all the time. And they both play off each other so well that it really helps things get done in the Moot Court Association. And I just want to give them another quick round of applause because they really helped this happen. I want to thank Shannon Hagan and Amanda Ross. They're going to be the authors of the Wagner competition fact pattern. They helped grade briefs. They basically were willing to help out at any point in time we asked them to, and went above and beyond the call of what their job description says. And you know what, in a world where a lot of people are willing to just, check it in when they've hit what they're supposed to do, it really is rare that you find people that are willing to do that extra work to help ensure something is not just good but great. So I'd like to give them a round of applause as well. And I know this list is long, but bear with me. I've got a few more people, and we're going to get underway. I want to thank Larry Ziegelbaum, who unfortunately couldn't make it today, and Alexis Silverman. They're the Wagner chairs and are going to be in charge of hosting the Wagner competition in the spring. They're just another example of two people who, were only required to put in minimal help to get this competition going. And honestly, they were here as much as myself, Gaurav, and Stephanie, helping ensure that judge reservations were taken care of, that judges knew where they were going, they were judging rounds, they were helping so much in the planning, and it was just so great to have them. And seeing how they worked in this competition, I can guarantee right now that this Wagner competition coming up in the spring is going to be probably the best one we've had all year and is going to really represent New York Law School in a positive light. So thank you, guys. Also, I want to thank Ethan Wishnick. I know the name sounds a little familiar to you guys. He has been so good at getting things together ahead of schedule. He was essentially in charge of scoring for this year's competition. And, scoring these competitions is a stressful thing because, the last thing you want to do is get numbers wrong, have some sort of formula be wrong, and it can ruin everything. And he was on top of it. He had the algorithms or the formulas ready for weeks in advance. And he really he turned around those scores so quickly. I mean, I know you guys kind of felt, I'm sure it seemed like it was forever when you were sitting in those rooms on Friday waiting to find out who advanced and who didn't. But honestly, he turned it around about an hour faster than they turned around the scores for us last year. And it was just a testament to, being prepared. And so I wanted to thank him very much for helping this competition go forward. And then I want to also extend a personal thank you to Joanna Wine, the vice chair of this organization. And she is incredible. I've had the pleasure of working with her now for 2 semesters straight. And she is somebody who is always prepared, always carries herself with a smile no matter what's going on, which, when you're in a room and everyone's stressed and everyone's arguing, having a personality and a presence like that is it's invaluable, and it really helps accomplish things and get things done. And honestly, I don't think I would be able to get my job done without her help. So I personally want to thank her, and I hope that all of you will help me do the same. And last, but certainly not least, I want to thank Stephanie, Scolo, Aris, and Gaurav Dave, the 2 Froessel co-chairs. They have put together an incredible competition, something that we've heard from alumni and from faculty and from all attorneys that have extended histories being involved in the Froessel competition, how well they did. I'm going to be honest right now, I have been ready to kill them several times throughout this process, but the way they've put everything together has just been incredible, and I'm in awe of how well they've really been able to work together. And I hope you guys feel the same way about this competition as I do, because I really, really, really am impressed with the work they've done, and I look forward to continuing to work with them because it's been a pleasure. Thank you guys very much.
Hi everyone, I'm Stephanie Scolo-Aris, co-chair of this competition. Along with Gaurav Dave, we've gone through a lot to make this competition happen. So I just want to thank everyone first for joining us here today. And as you may know, some of you as competitors don't know me that well because I was the side of running the judges of the competition. which was a difficult end of it, but Gaurav also helped me with that as well. So first, I want to thank the final round judges for coming today. We definitely have a great bench today, and I'd like to thank all the people who assisted me in getting the attorneys, practitioners, and judges that came along throughout this competition. If all of you don't know, this competition runs from Wednesday through Sunday. It's a long competition. We have many rounds, and we have to recruit many judges. And I just want to thank each and every individual judge that came through and actually judged this competition to challenge our competitors. I do have to also thank some people that Ian Thomas also thanked. I'd like to thank the whole E-Board and Moot Court Association members that went above and beyond to come and judge escort and timekeep, which is a very important role here. Also, I'd like to thank Sandra Davis, Kathy Wong, Jessica Aviles. Those were the people that helped me behind the scenes, hold the rooms down, and Sandra Davis ordering pizza, things like that. That was very important for us. I'd also like to thank Alumni Development, Tara Tomlinson. She helped us get in contact with the alum from this school to come and judge the competition. Some of them come back every year. We also tried to get alumni that knew about this area of law. I'd like to thank the faculty who served as judges, and also Tracy Parr, who helped me along with the CLEs. And also, everybody has to thank Professor Abraham, although you've already heard that from Ian Thomas. Professor Abraham has given us guidance throughout this whole competition. We went into this blind, and we had no idea what we were doing in the beginning, and she guided us through each and every moment of this. Lastly, I'd like to thank Gaurav for being my co-chair. He is the most focused individual that I know, and when something needs to get done, he gets it done. And when I got overwhelmed, which I often do, he was the one to balance me out and say, it's going to be okay, we're going to be able to get through this, it's great, don't worry, we're doing a great job. One special thing about Gaurav is he can come up with a solution in a second. So when something came up that I thought was a mess, he would say, oh, we'll just do it this way. And that's very important as co-chair for him to be able to balance me out in that way. When I first met Gaurav, I didn't know him at all. I am an evening student here, and only thing I knew of him was that he was in the final round last year, and that's all I knew. When I started working with him in April, I had no idea what to expect. But over 5 months, he has proven himself to be a hardworking individual, and I couldn't have asked for a better co-chair. That's it. I'll turn it over to Gaurav.
You probably can't tell, but I'm probably blushing a little right now. First and foremost, I'd like to say thank you to some people who helped bring this competition to life and also made my life a whole lot easier. First, I'd like to thank Sandra Davis. She's what we like to call Mother Goose. She's the gatekeeper. Nothing gets done, and all you new members will soon figure out when you're handing in receipts and whatever the case may be, Sandra is the first person we turn to for everything. So I really want to thank Sandra for helping us get this competition off the ground. We also want to thank Melissa and the rest of the marketing department who were great help in turning around everything we needed at the last second. Also, we want to thank Dean Matazar and the school administration. I think there's an assumption that most moot court associations are student-run, but that is not the case. We are one of the few wholly student-run associations in the country, and that is only because of Dean Matazar and the confidence and the faculty and the confidence they have in allowing us staff our own teams, run our own competitions, and pretty much handle everything from beginning to end. And along those lines, they've also provided a faculty advisor who I'd like to thank next, Professor Abraham, Susan Abraham. She's going to be one of the final round judges. She's usually a final round judge. She loves being on the final round panel, as she's more involved in this process, pretty much outside the E-Board more than anyone else. Sometimes we don't want to hear her advice. Sometimes we do want to hear advice. Either way, she always steers us in the right direction, because she knows that she represents the school's best interest, and sometimes as students, we let our emotions get ahead of us. But no matter what the case may be, she always guides us on the right path. I also want to thank the E-Board, Ian, Joanna, Ethan, the executive editors, Danny and Christopher Binns. I want to thank Amanda, and I also want to thank the co-authors, Harley Tenson and Avram Box, who, as I'm sure all of you know, created a fact pattern that was one of the most difficult fact patterns that we've seen in a long time. But that's, and you know, being students, we had so many attorneys, ALJs, and practitioners come up to us and say, wow, this was an amazing fact pattern, to the point where, you know, this is real life issues. It's stuff that you would see in an actual court brief. And, you know, I just want to give them a big hand of applause. That was a bit reluctant on their end, but I also next want to thank the Moot Court Association members, specifically Dave Sabors and Nick Tambone and Joe Mantino, Richard Geller, Beulah, a lot of people I'm forgetting, Michael Anslow. A lot of you guys really went out of your way, like Sarah Garrod. Pretty much everyone sitting in these front two rows, they went out of their way to help us out through the competition, put in extra hours that they were not entitled to do, but they did so because they understand that Stephanie and I we sometimes felt like we were on an island and it was just a disaster, and we needed every hand on deck to pitch in and get this competition off the ground. Some of you came up to me and said that this was a seamless competition. Everything was, for the most part, going pretty smoothly, and that's thanks to the collective efforts of every single person sitting in the front two rows, the e-board, and our faculty advisor, Professor Abraham. I'm sure you're sick of the thank yous. Just bear with me for one more, because I feel it's one of the most important ones. I want to thank Stephanie Scolo-Aris, my co-chair. All right. So I'm just going to give you some numbers. She organized over 50 rooms in the last 3-4 days, a logistical nightmare, I'm sure. And she successfully staffed over 250 judge positions. All those panels that were sitting in those rooms that you were arguing in front of was because of the incessant mails, emails, fire signals, whatever other modes of communication she sent out to the judges throughout the summer, all the return receipts. I mean, through everything, she was just a rock through it all, got these judges in. She was insistent and tenacious, and you know what, we hope that you guys appreciate all the hard work that she put in getting these judges to judge her rounds. And also she organized the time. She has an attention to detail that I don't. She said that I'm a focused individual, but I would look at her sheets and I would just draw a blank. I mean, she was just moving things around, and thank you so much once again. One thing I learned in this competition is the value of having a professional chemistry with your co-chair. And it's evidenced by the bond that Stephanie and I formed during the summer and especially during the last week, because, you know, whenever I needed something, she was there, no questions asked. And whenever she needed something, I was there, no questions asked. Not once did neither herself or myself complain that, oh, I'm doing her job or she's doing my job. It was just, we both were invested in the success of this competition, and we wanted to, you know, we wanted to staff a strong team, which I think we feel happy that we have. With that being said, I'm going to talk about the competitors. So friends, family, and faculty, we are here because of the diligence, the dedication, and hard work of the 30-something students we see here sitting today. To provide some context, 220 people initially signed up for the Froessel competition, and approximately 100 students, give or take, submitted briefs. Of these 100 students, the ones you see here today sacrificed an entire month of their summer to write the brief and gave up a whole week of school. They put it on hold because they simply would not be denied an opportunity to be on the Moot Court Association. This was by no means an easy fact pattern, as we addressed earlier. Thanks in part to the efforts of our co-authors, as well as to the efforts of Professor Nadine Strassen, somebody whom you might not, the two of us might not meet or know of because she's on sabbatical this year. But she worked as pretty much a faculty advisor to the fact pattern, and she was just, her efforts were invaluable in these efforts. The students attended various moot camps that we held during the summer, and although you guys were a bit hungover at times on Saturday morning, you guys were attentive, asked plenty of questions, and you made Stephanie and myself feel like the efforts were really worth it. You guys completed their briefs, you prepared to argue all four sides of the case, and proceeded to go through the intense prelim rounds, the double octo rounds, the octo rounds, the semis, the semifinals, and now the final rounds. So congratulations, you guys made it here. I would like to give yourself a big hand. With that out of the way, as tradition calls, I will read the biography of Charles W. Froessel. The Moot Court Association and the entire New York Law School community is proud to honor our distinguished alumni, Charles W. Froessel, by hosting this competition in his honor. Charles W. Froessel received both a Bachelor of Law and a Master of Law degrees from New York Law School in 1913. He was an honored leader in his profession who served the state of New York with distinction. His roles in public service included counsel to the Sheriff of Queens County, Assistant District Attorney in Queens County, Special Assistant to the United States Attorney General, Justice of the City Court of the City of New York, and Associate Judge of the New York Court of Appeals. Charles W. Froessel was also Chairman of the Judicial Section of the New York Bar Association and President of the Queens County Bar Association. Devoted to legal education and the law, he served with distinction as a professor and member of the Board of Trustees of New York Law School. At this point, I would like to introduce one of our executive editors, Daniel Costello, as he will read a final round judge biographies. Please give him a big hand.
Good afternoon. I'll tell you guys about the people who are making you four, or three right now, very nervous. First, we have the Honorable Ernest Rosenberger. After graduating from New York Law School in 1958, Ernest Rosenberger worked on public accommodation and voting rights cases throughout the South in the 1960s. He then came to volunteer his services in the defense of the Freedom Riders arrested in 1961 in Jackson, Mississippi. From there, he has served in many judicial roles in New York, such as judge in the criminal court of the City of New York, justice of the New York Supreme Court, and as an associate justice of the New York Supreme Court Appellate Division, First Department. Judge Rosenberger is currently of counsel at Strook, and Lavin, LLP, and serves as an adjunct professor here at New York Law School. Next, we have the Honorable D. Brooks Smith. D. Brooks Smith is a federal judge in the United States Court of Appeals for the Third Circuit. Judge Smith was nominated to the Third Circuit by President George W. Bush on September 10, 2001. Previously, he served as Chief Judge on the United States District Court for the Western District of Pennsylvania. Judge Smith was appointed to that court in 1988 by President Ronald Reagan. Might have been a professor, I don't know. Where he served until his election to the Third Circuit. The Honorable Jed S. Rakoff. Jed Rakoff is a United States District Court judge for the Southern District of New York and is a lecturer in law at Columbia Law School. He serves as a law clerk to the Honorable Abraham L. Friedman for the United States Court of Appeals for the Third Circuit and was an assistant U.S. attorney for the Southern District of New York. Judge Rakoff has co-authored 5 books, published over 100 articles, written over 600 judicial opinions, and given over 275 speeches. He received his J.D. from Harvard Law School in 1969, his B.A. from Swarthmore College in 1964, and his Master's in Philosophy from Oxford University in 1966. Nervous yet? The Honorable Susan J. Abraham. Professor Abraham is a professor of law at New York Law School, where she teaches evidence, advanced appellate advocacy, and principles of legal analysis. She also serves us as the Moot Court faculty advisor. She has represented indignant criminal defendants in New York and in New Jersey at both trial and appellate level. Arguing many times in the intermediate and highest courts, she has also represented clients in disability discrimination, employment, criminal, pension, and other matters. Susan Abraham earned her B.A. in English from Oberlin College in 1977, her Juris Doctorate from Rutgers Law School in 1983, and has received an MFA in creative writing from Warren Wilson College in 1999. Lastly, we have the Honorable Catherine Weiss. Catherine Weiss is Senior Counselor to Lowenstein-Sandler's Litigation Department and Director of Public Interest Advocacy for the Lowenstein Center for Public Interest. Ms. Weiss previously served as Director for the Division of Public Interest Advocacy in the New Jersey Department of the Public Advocate. Before entering state government, Ms. Weiss was Deputy Director of the Democracy Program at the Brennan Center for Justice at NYU School of Law, where she worked principally on voting rights issues. For more than a dozen years previously, she worked in the National Office of the ACLU, serving as Director of the ACLU's Reproductive Freedom Program. Ms. Weiss has also worked as a consultant to civil rights and human rights organizations and taught as an adjunct professor at Rutgers Law School in Newark. She clerked for Judge Alvin Rubin of the United States Court of Appeals for the Fifth Circuit. She also holds both a law degree and a master's degree in political science from Yale. Without further ado, I think I'm bringing Stephanie back up here. Thank you.
And now we will introduce the authors, Avraham Bakst and Harley Tenson.
Hi. Before we read the facts to you, I just want to extend another thanks to my co-author, Abe Bakst, for without his knowledge of free speech jurisprudence, we would not have this fact pattern, so thank you very much. Okay. In the summer of 1969, John L. Beadle, a billionaire musician, co-founded the Church of Beadle with his closest friends, Paul, George, and Ringo. Upon the church's founding, Beadle publicly declared that, for too long, people have been living with the fallacy that we are subordinate to some supreme guy in the sky. While such a belief may seem innocent enough, people inevitably end up fighting over whose interpretation of supreme being is correct. And we are forced into debate that only leads to hatred and violence. All we really need is love. Beadle then called for all those who believe in humanity alone as a method of achieving peace and love to join his congregation. Unfortunately, for the congregants of the church, the Beadles, this message was received with severe hostility by a majority of Lancashire's residents, some of whom resorted to violent tactics to intimidate the Beadles from espousing their message. The church's location in the heart of downtown Lancashire also proved to be an inviting target for malicious activity and vandalism, as 83% of the surrounding population were devoted followers of the Elders of Gaga. Throughout the summer, the church was repeatedly vandalized. Words such as heathen and blasphemer were painted across the walls, and the elders frequently harassed the Beadles. The tension finally came to a head on August 25th, 1969, when Christopher Costello, the leader of the Elders of Gaga, burned the church to the ground. Upon his arrest, Costello declared, "The God of Gaga called out to me to remove the symbol of blasphemy from within our midst." True to his non-confrontational nature, John Beadle issued a public response to Costello, stating, "These recent events make it clear that Lancashire is not ready for true enlightenment. Rather than continuing to subject our congregation to persecution, we are taking the church to a place where we can live freely and peacefully." Shortly after, John Beadle purchased a secluded farm 2 hours south of Lancashire. The farm was named Imagine, to challenge outsiders to imagine an enlightened future within the present. Tragedy struck Imagine in 1971. After serving a 1-year prison sentence for arson, Costello, convinced of his mission to bring an end to the church, shot and killed John Beadle on the steps of his front porch. Costello also lost his life after a violent shootout with a local sheriff. To realize John Beadle's vision of a land free of the majoritarian pressures of a capitalist society, the remaining co-founders purchased the surrounding farms, expanding Imagine to nearly 20 square miles. On July 4th, 1971, the town of Imagine was incorporated and recognized by the Froessel state legislature. At the time of the incorporation, the town charter contained the following provision. Upon thoughtful deliberation, the town of Imagine considers legislative prayer a religious exercise unbecoming of the American tradition. As such, the council is hereby prohibited from engaging in the recitation of prayer during any legislative function. Following incorporation, the council did not engage in the practice of legislative prayer for nearly 2 decades. In 1997, war completed construction of the world's largest weapons factory. The factory is located 1 hour north of Imagine. The factory employs nearly 5,000 full-time employees. Approximately 3,300 of these moved to Imagine, creating a significant increase in the town's population. This population boom also brought with it a huge shift in social and political points of view.
The council election of 1998 proved to be particularly divisive and resulted in enmity and hostility among the council members. Thereafter, Imagine's legislative process that degenerated throughout the 3 years preceding the 2001 election, and consequently the council was unable to pass much needed legislation during this period. In 2001, Councilwoman Stephanie Wine ran for a re-election on a platform stressing the need for unity and nationalism in a post-9/11 world. While making a statement at the annual Fall Music Festival commemorating the life of John Beadle, Councilwoman Wine attacked the charter provision prohibiting legislative prayers, stating legislative prayer is a long-standing in our nation's history, and deeply rooted, rather, in our nation's history and tradition, and serves the important purpose of uniting parties and reminding legislators that they are engaged in serious business. Imagine has been run by anti-religious hippies long enough. This town needs God to guide us. Upon her re-election, Councilwoman Wine immediately proposed a bill amending the charter to provide for legislative prayer. Subsequently, on March 4th, 2003, the council passed 47 ITO Section 1954, which requires an invocational prayer prior to any town council meeting. The invocation is offered on behalf of the council members and the citizens of Imagine, but the invocation must receive prior approval from the council chairperson. Invocations were offered by a variety of individuals with a myriad of religious beliefs, and the chairperson would just simply open the floor to anyone who wished to come forward and offer an invocation. Approval was given as a matter of course. On other occasions, council members would offer invocations themselves or invite other parties to offer an invocation on their behalf. The record does not reflect any objections to the prayers offered during this time. However, in 2009, an incident occurred resulting in an amendment to ITO Section 1954. On January 5th, 2010, as per his usual practice, Chairman Lawrence Thomas opened the first deliberative session of 2010 by inviting anyone who wished to offer an invocation to come forward. With approval of Chairman Thomas, Ian Wishnick approached the floor and proceeded to offer the following invocation. Citizens of Imagine, join me in offering a prayer not to a divine creator, but to humanity. Imagine there is no heaven, no hell below us, above us only sky. Imagine all the people living for today. There will be a time of no religion, when we all live in peace. Imagine sharing all the world. We must live as one, a brotherhood of men. You might say I'm a dreamer, but I assure you I'm not the only one. I hope someday you'll join us so the world may live as one. In beseeching the wisdom of this council, I hereby invoke the divine guidance of the beetle gods and their message of peace and love. I pray in the names of John, George, Paul, and Ringo. Amen. You guys are a bit more tolerant than the town of Imagine, it looks like. But as seen, pandemonium ensued in Imagine, and council members and citizens stormed out in protest. The tension between the two religious groups escalated into violence and vandalism, leaving the several congregants hospitalized in critical condition. Subsequently, the council was inundated with demands that it take the necessary measures to ensure that polytheistic views do not pervert the purpose of the prayer practice, and making it clear that such offensive behavior will no longer be tolerated in Imagine. On September 11, 2010, Imagine Town Ordinance, Section 1954, was amended to provide, first, any party may request to offer an invocation on behalf of the council and citizens of Imagine. Second, all requests must be submitted in writing at least 30 days prior to a desired council meeting and include the full text of the proposed invocation. 3, a party may not offer an invocation without approval from the chairperson. 4, the invocation may not reference a particular religious tenet or specific deity. 5, all invocations for divine guidance must be made in the name of God, in accordance with the American civic tradition. 6, any person deviating from the approved invocational prayer guidelines will be subject to a fine of $1,000 and prohibited from giving the invocation for a period of 5 years. On January 15, 2011, Wishnick submitted the following written invocation for approval in accordance with Section 1954. I ask that this council receive guidance on behalf of itself and on behalf of the citizens of Imagine, so they may understand the importance of their work and understand that it is only through unity that we as a people can come together. I pray in the names of John, George, Paul, and Ringo. Amen. Chairman Thomas rejected Wishnick's invocation for violating the terms of ITO Section 1954. Chairman Thomas explained that Imagine's non-sectarian invocations are traditionally made to a divinity consistent with our nation's monotheistic traditions, noting that polytheism is not consistent with such a tradition. Wishnick subsequently filed suit under the First Amendment's free speech and establishment clauses in order to prevent enforcement of the amendment, Section 47, ITO Section 1954. I would also like to take this opportunity while I have the mic and before they take it away from me to congratulate all you as a collective group. It really means a lot to me, the effort and amount of work put into this by you guys as a collective group. Thank you so much.
Thanks again, Harley and Avram. At this point, I want to remind everyone in the room to please turn off your cell phones. And we ask that everyone conduct themselves as you would in a courtroom, no conversations, as the judges will be sitting facing you. At this point, the court is now in session.
All rise. Oyez, oyez, oyez. All those who have business before this, the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. The Supreme Court of the United States is now in session. Justices Abraham, Rakoff, Rosenberger, Weiss, and Chief Justice D. Brooks Smith presiding.
Please be seated.
The first case on the calendar this 18th day of the month of September is the Town of Imagine petitioner against Ian Wichnick respondent.
Yes, we'll call the case of Town of Imagine versus Ian Wichnick. Mr. James.
Good afternoon, Chief Justice, Your Honors, and may it please the Court, I am Matthew James, along with my co-counsel, Ms. Arielis Tomnik, for the petitioner, Town of Imagine. At this time, with the permission of the Chief Justice, the petitioner would ask for 1 minute's rebuttal time.
Granted.
Thank you, Your Honors. The case before the Court today is about petitioner's ability to fulfill its solemn duty to promote both unity and solemnity before its town council meetings. The petitioner has chosen to do so through a duly legislated ordinance, that is, Imagine Town Ordinance Section 1954. Petitioner today will be asserting a two-part argument, beginning with the Free Speech Clause of the First Amendment, which properly analyzes legislative implications pursuant to ITO Section 1954 as government speech. My co-counsel will then proceed to establish that the First Amendment's Establishment Clause is best applied to ITO Section 1954 within this Court's precedents, that is, as a sui generis issue. Beginning with the subject of government speech as applied to ITO Section 1954, it's instructive to look at this Court's ruling in Johannes, which says that where the government sets the overall message and approves every word to be disseminated, it is in fact government speech.
Well, do you approve every word?
Yes, Your Honor. Pursuant to ITO Section 1954, not only is the submissions themselves screened for content beforehand, but the councilwoman, councilperson, the chairperson, will be approving or disapproving the message based on whether or not it is in compliance.
Well, but beyond approval of the words themselves, the entire scheme that was present in Johannes was much broader and far-reaching than what we have with your ordinance, was it not? We had an act of Congress, the Beef Promotion Research Act, and then behind that act and the policy of it, the statute directed the secretary to implement the policy in a particular way through the issuance of a beef promotion and research order, and then the secretary was responsible for appointment of the members of that, and then there was an operating committee. This was extensive government activity here in Johannes. Do we have the same thing in this case?
Yes, Your Honor, we do, because in this case, we have a situation in the town of Imagine that is petitioner has a situation within the town of Imagine to address, namely the discord and disunity throughout the town manifesting itself perhaps even in violence. And the town council was directed to enact whatever legislation is necessary to promote unity and solemnity.
I understand that's the policy behind it, but my question is, to what extent is there involvement on the part of the town and its government in review, approval, implementation, as compared to the kind of structure that I just mentioned that was inherent in the Johannes case?
Well, Your Honor, after mandating that the council will in fact enact some form of legislation to address the issue, ITO Section 1954 was passed, and the provisions of ITO Section 1954 specifically prohibit any specific religious tenet or religious philosophy being included in a given invocation, as well as mandating that the term God will serve as a general umbrella term for a divinity as opposed to any specific deity associated with any specific religion. Add to that the chairperson's ability to screen for compliance with ITO Section 1954 and the ultimate power of rejection or acceptance. And petitioner asserts that this case, in fact, falls within the provisions of Johann, or rather within the holding of Johann and by extension Summum, Your Honor.
This has to be triggered, does it not, by someone outside the government? The whole thing only comes into operation if someone outside the government says they want to give an invocation, yes?
Yes, Your Honor, it is true that the ITO Section 1954 does in fact invite people to convey the government's message, and yet the message remains that of the government throughout. A message that is an acknowledgement that everyone on the council, including respondents and citizens of Imagine, are in fact fallible human beings united in their efforts to carry out a solemn duty.
Well, but wait a minute. Subsection 1 of the ordinance states, any party may submit a request to offer an invocation on behalf of the council and citizens of Imagine. If this speech can be made on behalf of the citizens, how is it solely a matter of government speech?
Your Honor, when we look to the phrasing of subsection 1, which says that, well, as Your Honor just said, that it's on behalf of the council and its citizens, the council is in fact duly chosen by the citizens themselves. The council should be reflecting the citizens' choice. In this case also, we look to subsection 5, in which the American civic tradition is specifically referenced. Read in tandem, subsections 1 and 5 lay out that the invocations offered on behalf of the town council and its citizens are an effort to maintain an American civic tradition.
Now, does that mean that if the town of Imagine had a tradition different from the American civic tradition, that the American civic tradition would trump the unusual history of the town of Imagine?
Your Honor, that seems like a bit of a compound question, and to answer, I would
That's
say
my favorite kind.
And we have no objections here of an evidentiary nature.
It is an interesting opportunity for petitioner to assert that in religious matters, the American civic tradition takes on special importance in allowing an invocation to remain non-sectarian. We're not discussing the subject of, say, baseball or some secular regulation, in which case...
You don't think baseball is religious?
Perhaps for some, Your Honor. Respondent has raised no claim regarding.
Counselor, may I ask, since you've touched on the Establishment Clause problem, do you not have a tension in this case between your argument and your colleague's argument, in that the more insistent you are that the government entirely owns and controls this speech, the more the government is itself offering the prayer? And I have several questions about whether this prayer could ever be characterized as non-sectarian, but that I will reserve for your colleague. But do you not open the door to winning on the Free Speech Clause only to lose on the Establishment Clause?
Your Honor, at the risk of, as you said, straying into my colleague's Establishment Clause argument, I would say that that is precisely why it is so important that the town of Imagine maintain tight control in its enforcement of the non-sectarian invocation, to ensure that though it is screening for content in the sense that it will not allow specific religious tenets, it is doing so in order to keep from affiliating with any one specific religion.
But, so you say. However, in this particular instance, you rejected one, which is why you're here. But what substituted for it runs head-on into the stated reason for rejection.
Your Honor, in the town of Imagine, at a very, I'm sorry, let me restate that, Your Honor. petitioner would say at a very high level of generality, God may be used as a very general umbrella term for any number of religions. Within the town of Imagine, there's a unique history involving the elders of Gaga, in which a conglomeration of Judaism, Christianity, and Islam have actually come together in such a way that it hasn't been seen anywhere else on earth. However, those particular religions all share a common theme in their monotheism. And perhaps the Church of Gaga may or may not, as a policy matter, fall within ITO Section 1954. However, the proper forum for discussing that from respondents' viewpoint should be in the forum provided by petitioner. That is, the town council meeting itself. When people are offering, citizens that is, are offering invocations, there's no expectation that the town will then somehow answer the invocation in terms of approving it. Therefore, it is not a forum for discourse. It's simply conveyance of a message. The town council meeting afterwards is a forum where the respondent would be free to voice his concerns about the merits of allowing the Church of Gaga to be referenced.
Mr. James, I'm sorry to interrupt you, but there has been much written about this doctrine of government speech, and it's been criticized by some as an artificial doctrine, as a way for this court to avoid an Establishment Clause analysis. If this court were to reconsider the government speech doctrine itself, what would you say to that? Is there some alternative argument, or why should we maintain the government speech doctrine as a legitimate doctrine?
Your Honor, to answer your question in turn, petitioner, without abandoning its view that this is, in fact, government speech, would say that even under a government forum analysis, if indeed this petitioner has somehow set up a limited public forum in the form of legislative invocations, surely, as this court has established in Perry Education Association versus Perry Local Educators Association, they do have the means and the right to enforce that forum and see that it is used as they intended. In this case, respondent wishes to use that forum for his own intents, namely to question whether or not monotheism is in fact in keeping with the American civic tradition. As for the merits of the government speech doctrine itself, this court has enforced it specifically to address the kind of concerns previously addressed by Justice Weiss, in that without the ability to ensure that invocations are non-sectarian, governments would run the risk of officially affiliating themselves with a given invocation simply because they could not stop any given citizen from claiming that the government had endorsed their God.
Well, assuming, as we must, that the government speech doctrine remains good law and is supported by precedents of this court, admittedly, it is relatively new, and the precedents are not manifold in number. Have we really stated a test with any degree of specificity as to what should constitute government speech? And if we have not done so to a very specific degree, would you urge upon us any particular test to adopt that we could apply to your assertion of government speech here?
Absolutely, Your Honor. As you said, there is precedent that exists, and in the Fourth Circuit, in Page versus Livingston County School District 1, it was said that, referencing Johans, a decision by this court, that Johans in fact distilled the elements necessary to determine what level of control is necessary for a government to claim government speech, namely being the government's ability to create, editorially control, identify the speaker themselves, and retain responsibility for the message afterwards. And we would urge that court to look to the Fourth Circuit and adopt their standard.
Well, using that standard, doesn't this particular circumstance, isn't it distinguishable from the other situations in which government speech was found to exist, in that there isn't really a particular message that the government is trying to put forward? Rather, it's examining other people's messages to find whether there's something objectionable. And to call it government speech when it really seems to be only editorial control and not one specific message that was determined ahead of time, doesn't that differ from all of the other government speech situations that we've recognized?
Respectfully, petitioner disagrees with that particular assessment, Your Honor. In Johans, it was a very broad, well, admittedly broad criteria criteria set out that the government set the overall message and control every word disseminated. And using the Fourth Circuit's, as suggested, using the Fourth Circuit's analysis, which breaks down that level of control, we see that the government can, in fact, exert that level of control here.
Forgive me, but in Hans, the message was clear. It may have been somewhat general, but it was clear it was buy beef. Presumably because it was so good for your heart. So what's the message here? What is the message that the government of Imagine is promulgating?
Your Honor, petitioner reiterates that the message going forth in these invocations is that the town of Imagine, despite the many different kinds of religions present within its borders, is composed of fallible human beings, each tasked with a solemn duty in the form of the legislature. And that in recognition of the American civic tradition of reminding legislatures of that solemn duty through an invocation to a monotheistic God, again in keeping with the American civic tradition, that they will endorse that particular reading of the word God, not in a sectarian way, but in keeping with its historical tradition.
Counselor, suppose we think that there's a disjuncture between the stated purpose of the ordinance, which you've just described, and the way the ordinance has actually been, we'll extend your time so you can answer this question, and the way the ordinance has actually been observed and enforced. What do we do? Is this a facial challenge? Are we ruling on the words of this ordinance, or are we ruling on how this ordinance has in fact been enforced in the town of Imagine?
Your Honor, I believe that this court, petitioner would assert that this court is examining this as a facial challenge, meaning that respondent is asserting that ITO section 1954 has in fact, in and of itself, is unconstitutional. In fact, he is not even calling to question, or has not raised the issue of how it should be applied to the rest of Imagine. He has merely said that ITO section 1954 violates both free speech and establishment clauses. Petitioner contends that it does not.
Thank you, Mr. James. We'll have you back on rebuttal.
Thank you, Your Honor.
Ms. Patelnik.
Good afternoon, Chief Justice Smith, Your Honors. My name is Ariella Spitalik, and I will be presenting the Establishment Clause issue on this appeal. Petitioner asks this court to reverse the decision of the Court of Appeals for the 13th Circuit and find that ITO section 1954 does not, in fact, violate the Establishment Clause of the First Amendment. I will argue that ITO section 1954 does not violate the Establishment Clause for the following reasons. First, the invocations given at council meetings constitute legislative prayer as established in Marsh v. Chambers as free from constitutional attack under the Establishment Clause. Second, ITO section 1954 still passes constitutional muster under traditional Establishment Clause jurisprudence as outlined in Lemon v. Kurtzman for the following three reasons. First, the ordinance has a primary secular purpose. Second, ITO section 1954 neither advances nor inhibits religions. And third, ITO section 1954 does not result in excessive government entanglement with religion.
Counselor, didn't this court decide Marsh as a narrow exception to the Lemon test for the precise reason that there was no way that legislative prayer mentioning God could pass the Lemon test?
Respectfully, I agree that the Marsh holding construed legislative prayer narrowly. However, in terms of the process that is being put forth here and the type of prayer that is being presented, I would argue that, or rather petitioner asserts that the invocations here would fit within that mold for the reason that the invocations or the legislative prayers discussed in Marsh are presented for a council meeting. They are presented for the purpose of introducing a council meeting, and they are presented for the purpose of setting the tone of solemnity and unity among the citizens and constituents and the council, the legislators present. The purpose of the...
Counselor, do you have to invoke, what is it, Almighty God, Gaga, to solemnize a legislative session?
I would agree you do not have to. However, the purpose of legislative prayer as established in this country has been to to recognize universal values of God and the function of our legislatures under the godly values of the nation's history and religion and
I think you have a big problem in your record, okay? One of the problems you have in your record is that the history of these invocations have invoked a specific deity in direct contradiction to the ordinance throughout the time they've been used in the town of Imagine. And the other serious problem is that the history of violence and, arson, crime, murder that attended all of this suggests that a response that elevates one of the warring sections, indeed the more violent one, according to this record, over the other one, would not be a response that would be likely to promote the unity you claim. Would you like to address those two problems in your record?
Sure. As far as which I believe you are referring to the reference to Almighty God Gaga in the first part of your question, that, as my co-counsel has stated, has been the majority tradition of the town of Imagine for a long time, since its inception.
Since its inception. I understood these facts to say that for the first 30 years, legislative prayer was banned in Imagine and that it had a secular humanist founding and long history before the elders of Gaga settled there rather recently.
Excuse me, Your Honor, you are correct. I will retract that. As the town continued to develop and populate and change, the recognition of the Almighty God Gaga became a majority faith, I would say, that is a conglomerate of various religions and that exists in the monotheistic guise of one God, which is consistent, again, with our historical tradition in this country, the monotheistic values of God. As far as your second question regarding the non-sectarian requirements, again, this monotheistic conception of God is the invocation under the monotheistic tradition is used to recognize a non-sectarian overall tradition of God's universal place and how our country functions under a larger tradition of
I'm trying to figure out how you can rely upon Marsh. Assume that we followed Marsh as an analytical path here. Don't you have a problem with subsection 5 of your ordinance? By the manner in which it elevates, it makes primary religions with a particular conception of a God. They were not the facts, and that was not the nature of the legislative action of Nebraska in Marsh, was it?
Your Honor, I believe it was, in fact. Perhaps I am incorrect. However, the general idea of the invocations in Marsh were similar to the idea of the invocations here. The invocations here were to be non-sectarian. That was for the idea of promoting a unity in the town and security in response to the violence that had occurred. Whereas in Marsh as well, there was a non-sectarian requirement. Whether the word God was allowed to be used, I'm not sure at this moment. I can submit that in the brief. However, I believe the message, the overall tone and the message that was transcribed in the invocations in Marsh was the same. On that note, I would like to move on to my next point, which is that even under traditional Establishment Clause jurisprudence, the statute here still passes constitutional muster because it has a primary secular purpose. It also has an effect which neither advances nor inhibits religions, and it does not involve excessive governmental entanglement with religion.
It doesn't?
Your Honor, respectfully,
Well, let's put aside the word excessive for now, and let's just look at the word entanglement. What's the role of this community in passing on the acceptability of a particular prayer?
Would you mind clarifying your question, Your Honor? I apologize.
What's the role of the municipal government in passing upon the acceptability for purposes of delivery at a meeting of a particular prayer?
The role of the government in bringing forth these invocations is to set the tone of solemnity, and the role of the government as well in approving or disapproving the invocations was, again, just to make sure that the requirements...
What does the town council do? What do they actually do? What is their participation in this process?
Their participation is to give final approval, Your Honor.
So they are editor, censor, what are they?
I would say neither. I would say that, petitioner asserts that they are merely trying to assure that the invocations that are suggested meet the broad requirements of the statute. They are not editing the message. The message that is being presented is coming from the citizens, and the citizens are aware that if they present it within these broad guidelines, that they will be approved and they will be allowed to present their invocations.
But looking at this particular instance, aren't they both editing and censoring?
Your Honor, I would say they're not. I would not say that they are editing, because Mr. Wishnick has not had any form of collaboration in his presentation of the invocation. He wrote it himself. The council is merely telling him that these invocations that he is trying to suggest do not meet the requirements.
Isn't that censoring?
That is, I guess it depends how you look at the word censoring, Your Honor.
Okay.
However,
How do you look at it?
I look at the word censoring much stronger. Censoring is for the purpose of telling certain people that they are not allowed to speak at all. In this case, the council has provided him the opportunity to present his invocation and to present it from his own viewpoint. However, those viewpoints that he was trying to present it caused pandemonium and violence, and for the purpose of maintaining the security of the town.
But, Counselor, isn't that just why the Establishment Clause exists? Isn't it that the Establishment Clause exists in part because we in this country sought to avoid divisiveness in the political community based on religious affiliation? That isn't separation and neutrality, right? The two principles that animate the Establishment Clause, don't they exist? Because what we are seeking to avoid is pandemonium in our legislative chambers because somebody believes in the Beatles and somebody believes in Gaga. That is not, we tolerate divisiveness, heaven knows, of all kinds in our legislature. A level of divisiveness that is dysfunctional, we tolerate. But we don't tolerate it based on religious schisms. From the very founding, it's been part of the purpose of the Establishment Clause to avoid that. And I look at this record, and I see that Imagine began by forbidding legislative prayer and lived in peace. Then it allowed legislative prayer, and things went well until one arose, as one always will, that someone didn't like.
You may or may not know whether that's a question.
I believe I can respond, Your Honors.
Good.
Petitioner agrees with you that that is the purpose, the very purpose of the Establishment Clause. In that manner, I would agree, I would assert rather, that petitioner, the town of Imagine, has written the statute for that very purpose, towards that very goal. The statute as written is to provide non-sectarian invocations and to invoke only the divine guidance of God in a general way that is in accordance with our tradition in this country, that has been recognized in terms such as "In God We Trust," which is in courthouses, and in currency, and in the Pledge of Allegiance as well. This has been a term that has been recognized as uniting people and as acknowledging our sense of tradition and our sense of the founders and their purpose in drafting the Constitution.
Counselor, doesn't your argument that the town council is neither editing nor censoring undermine your co-counsel's argument that it's government speech? Aren't you saying now that that it was Wishnick's message and not the town council's message, and that the council's only job was to make sure it conformed with the statute, but it wasn't their message? Doesn't that undermine your associate's argument?
It does not, in the fact that my co-counsel has presented an argument about a forum, whereby the government is allowing private citizens to come forward and to present their own personal messages within certain restrictions. The forum, pardon my approach into the free speech issue, but the forum here was to present a place where citizens could express their views and could come speak in the legislative chamber, which is what the council has tried to do, whereas Mr. Wishnick has come forward with a message that is not consistent with the requirements of the statute, and therefore the town was required in response to limit him and to tell him that he must follow the requirements if he wants to be able to present invocations in the future.
To put the question another way, how can you have a personal message and a government message at the same time?
You could have a personal message and a government message in that the government is allowing or is creating a space for private citizens to come speak. And in the idea of...
That only makes available a place for them to do so. That in and of itself does not imply an adoption by government of what that personal message is, does it?
I believe, Your Honor, in the idea of a limited public forum, the government is allowed to place reasonable restrictions on a private citizen as long as those restrictions are reasonable and non-viewpoint discriminatory, which is the case here. Which is why I believe that also, petitioner asserts rather that the invocations being,
Sure, please.
Thank you, Your Honor.
Complete your answer.
The petitioner has allowed Mr. Wishnick to come forward and citizens to come forward and present their invocations, have provided this limited public forum with certain restrictions that must be reasonable and viewpoint non-discriminatory, which is the case here. The restrictions are merely that the invocations be non-sectarian and invoke only the universal idea of God, and Mr. Wishnick has failed to comply with these restrictions. Thank you very much.
Thank you, Ms. Potomac. Mr. Kleinman?
Good afternoon, Chief Justice, Your Honors. May it please the Court. My name is Randy Kleinman, and I, along with my co-counsel, Mr. Jalil, represent the respondent, Ian Wishnick, on this appeal. We ask this Court to affirm the decision of the 13th Circuit and hold that ITO Section 1954 is unconstitutional under the Free Speech and Establishment Clauses of the United States Constitution. Respondent must first point out some blatant flaws in the petitioner's argument. The petitioner stood up here, Your Honors, and argued that while ITO Section 1954 is discriminatory, it is discriminatory for the purpose of conforming to American history and civic tradition, which the respondent reminds this Court is Presbyterian in nature and not non-sectarian. Additionally, the petitioner argues that ITO Section 1954 creates a forum, a traditional public forum, which in turn requires strict scrutiny. And this statute...
First of all, thank you, counsel, for coming here on the Lord's Day to argue this interesting case. But is there such a contradiction? What I understood your adversaries to be saying is this was government speech because it served, the government wanted to assert that before beginning a legislative session, the members of the legislature should understand that they were not God, contrary to their own personal beliefs, but that they were fallible human beings, and they should take this matter in that tone. And to enable that message to carry full weight. They allowed outsiders, members of the community, to express a wording, different wordings, but all having that same message which the state was trying to convey. What's wrong with that?
Well, Your Honor, you're correct to point out that the presented purpose is unity and solemnity in the town of Imagine, which respondent doesn't argue, if in fact this was the purpose, would be noble and legitimate. But it's clear that the records replete, Your Honors, with evidence of viewpoint discrimination. And I'd like to draw your attention to Johans versus Livestock Marketing, which the petitioner attempts to use as their argument to argue that it is in fact government speech when there's clear distinctions between this case and that case. In Johans, the court explicitly said that in order to be government speech, the legislator or the government must retain significant control of the message from the beginning to the end.
Well, isn't that true here? They set out it's got to not reference a particular religious tenet or a particular deity. It must, all invocations for divine guidance must be made in the name of God. And then they have the chairperson doing the more fine-tuning of the message in a way that the government had the opportunity to fine-tune in Johans.
Your Honor, you're correct to note these things. However, the degree of editorial control is just absent. That was there in Johans. Here what we have is content-based facilitation and not anything near the level of editorial control where a government creates a program from the beginning, sees it through to the end, enables the Secretary of Agriculture to come in and appoint and remove officials on this program, and also to control the message. If the message was simply a private citizen, which I urge this court to realize that that's what we're dealing with, if the message was simply the private citizen going up and saying the word God, then yes, the government would retain significant editorial control. But here, it allows private citizens to come in and invoke a message in their own personal, creative sense, and to invoke a message that Johans simply didn't allow for these individuals who were under the government's control to do. And I'd like to draw your attention now to Pleasant Grove versus Summum, which the petitioner also relies on to say that this is government speech. And in Summum, the court...
Supposing, just so that I understand, supposing the City Council of Philadelphia decided to pass an ordinance that said we are going to open every session by expressing our hope that the Phillies win the World Series. And we are going to allow any Phillies fan, in fact, any citizen, to suggest the wording, but it'll have to be subject to first, it has to be carry that basic message that the Phillies will win the World Series. So if there's any Mets fans out there, too bad for them. And secondly, that we will look it over to make sure that it really fairly and accurately conveys that message. Wouldn't that be government speech?
Well, Your Honor, in that scenario, the government retains control of the overall message. And in that scenario, it would in fact seem that it, perhaps depending on the actual message that was actually invoked, would in fact be government speech. But here, it's completely distinct because, again, it's one word. And the government isn't telling the individuals how, in fact, to use it. Actually, they are, and in the way they are, it's viewpoint discriminatory. And
Counselor, do you have the opposite problem that your opponents have, in the sense that the more you argue that this is really personal, private speech in a public forum, do you agree with me first that a public forum exists to allow private speech to occur?
Yes, Your Honor.
Okay. So that it is therefore not government speech that occurs in a public forum. The public forum doctrine exists to protect personal speech.
Correct, Your Honor.
Okay. So the more you argue that this is a public forum, the less the government is associated with the religious message, and the more difficult your Establishment Clause challenge. Is that true?
No, Your Honor. And for the sake of stepping on my colleague's toes, my co-counsel's toes, I will answer that question in that there are two distinct issues. And free speech is entirely distinct from government entanglement in religion. And despite the obvious obvious lack of editorial control we have here, a forum itself, for example, I draw your attention to Arkansas versus Forbes. And there the government actually goes through a three-part analysis of the different types of fora. There's a traditional public forum, a designated public forum, and a non-public forum. Now, what they had there actually was similar to the case at bar, Your Honor. There was a government-controlled television station, and there was a public debate, a public government debate which the government station controlled. And here we had a non-public forum, which is still prohibits viewpoint discrimination. So irrespective of the specific forum this might fall in, it still cannot have viewpoint discrimination. And as petitioner argues, this is a designated public forum which requires strict scrutiny. And this statute simply, although the purpose might be compelling, is not narrowly tailored to meet that goal and clearly fails. And
did petitioner argue that this was a limited public forum, or what you're calling a designated public forum, or did they argue that it was government speech and that therefore viewpoint discrimination is permitted?
Your Honor, at the crux of their argument, essentially they did admit that this was in fact a limited public forum, which is in fact a subset of a designated public forum and still entitled to strict scrutiny. And even if it were a non-public forum, it would be entitled to rational basis scrutiny, but still they cannot discriminate based on viewpoint. And the court in Perry versus Perry, in Rosenberger versus the UVA, and in Arkansas versus Forbes was clear in this matter. But to draw our attention back to the issue at hand in regard to the government speech, it's important to assess the facts from Pleasant Grove versus Summum, where there the court said the government had two interests that made the case distinct. One was control. The government controlled the land and controlled which monuments could in fact be presented in the park. And the second was the unique nature of the monuments. So the government has an overwhelming property interest in maintaining the sanctity and maintaining the space of a land. And the court was clear that there's a fundamental distinction between a speaker's corner in which anyone can speak and a monument that is permanent and has an imprecise message. And this is clearly reflected in Justice Alito's opinion when he says, speakers, no matter how long-winded, eventually come to their end. Monuments, however, endure. So be that as it may, this is clearly a ITO section 1954, subsection 1, allows any citizen to make an invocation. ITO section 1954, subsection 3, requires that all invocations for divine guidance have the chairperson's approval. And ITO section 1954, subsection 4, requires that all invocations be non-sectarian, and subsection 5 requires that all invocations use the word God. Your Honors, this is a clear case of doublespeak where the government is saying, let these invocations be non-sectarian, but use the word God, and polytheists need not apply, is what it might as well say, because it's completely, and this leads right to my third point, Your Honor, discriminates against the viewpoints of those who refuse to conform to the normative, societal, monotheistic values. And this is simply not what our Constitution, or for that matter, what Mr. John Beadle had in mind when he started Imagine. Mr. John Beadle founded Imagine under the premise of what the government uses as a facade of unity and solemnity. And if that's what this statute actually, in effect, did, then yes, it would be legitimate. But here, we have clear discrimination. I draw your attention to the district court opinion at page 5. And there we can see that Mr. Wishnick's invocation, which the respondent concedes did in fact violate the provisions of ITO section 1954, was rejected as he invoked the names of John, Paul, and Ringo. But in its place, as indicated by footnote 7, was an invocation by Mr. Binns that said, Almighty God Gaga. This is not non-sectarian. This is attributable to a monotheistic God, Your Honors. And this, since it replaced Mr.
Counselor, let's suppose we agree with that position. that does not represent a non-sectarian practice. Are we evaluating the practice or are we evaluating the ordinance?
Your Honor, this statute facially is discriminatory in that it essentially contradicts itself and performs doublespeak in the most Orwellian sense. And it's also, as applied, clearly, since the facts and the record, the district court's opinion on page 5 indicate, and again, the legislative history, if I draw your attention to page 3 of the district court opinion, where Councilperson Wine stood up and as part of her campaign platform to unify the town, said, "This town has been run by anti-religious hippies for long enough." This pejorative term, this way to describe the people who were...
Counselor, if I may, I'm sorry for interrupting, but couldn't this be argued that it's an appropriate time, place, and manner restriction, that during the invocation is not the appropriate time to put forward a particular point of view? It's only a time to solemnize the occasion, but then 5 minutes later during council meeting, people can say whatever they want. So if you look at it that way, where's the free speech violation?
Your Honor, respondent isn't sure that he understands completely what your question is, but to answer it as best as possible, when you open the doors, when the government opens the legislative chambers to private citizens, it's completely unlike any other case that this court has seen before. It's a case of first impression. Your Honor, cases such as Snyder versus Murray City and Pelfrey versus Cobb County and Simpson versus Chesterfield all use clergymen only and never used private citizens. So the First Amendment is to protect private citizens, not counsel.
Are clergy not members of the public,
Well,
subject to First Amendment protection?
Correct, Your Honor. You're correct in pointing that out, and respondent misspoke in a sense. And in Turner versus City Council, where the council members and the mayor alone were the ones giving the invocations, these two are all the types of cases that this court has seen under this jurisprudence. And in that case, actually, Justice O'Connor in 2008 in the 10th Circuit, sitting by designation, opined a 4-part test to determine whether or not legislative prayer is in fact government speech. And the very fact that this test exists alone on its face states that even Justice O'Connor felt that there are possibly situations where legislative prayer would not be government speech. And this test looks at the central purpose.
In the framework of this case.
Would you mind repeating the question, Your Honor?
What are those considerations in the framework of this case?
Yes, Your Honor. There are actually 4 parts, but the first part looks at the central purpose, and here conceding that even if deferring to the town of Imagine, Your Honor, I see my time's up. May I please continue?
You may complete your
Even deferring to the legislator and assuming that they have a legitimate purpose, it fails the other 3 parts of this test with flying colors. The second is the degree of control. And as has been demonstrated, there is a significant lack in any editorial control, and it's merely subject matter control, which Snyder versus Murray City said was okay. They could limit it to legislative speech and legislative invocations because otherwise there would be essentially pseudo filibusters coming into the legislator, as Justice Abraham said before. And the third is the identity of the literal speaker. And this is where the town simply cannot pass muster. And here the identity of the literal speaker is clearly a private citizen who no reasonable person coming into a legislative session would look at and think, this is a government message. Just as a citizen doesn't, by virtue of the government's existence, adopt a message of every politician, thankfully, that gives a speech.
All right, I think we understand your answer. Thank you, Mr. Klein.
Thank you for your time, Your Honors.
Good afternoon, Chief Justice. Good afternoon, Your Honors. May it please this Court, my name is Noor Mustafa Jalal. I'm here today on behalf of Mr. Ian Wishnick, the respondent to this appeal. Your Honors, at its core, this case is about individuals being forced by their government to choose between their ability to participate in the political process on the one hand and their most personal and precious beliefs on the other. Now, fortunately, we live in a nation where Congress, and indeed all 50 of these United States, shall not make a law respecting an establishment of religion. Now, I respectfully implore this court to find that Imaginetown Ordinance Section 1954 is indeed unconstitutional and in direct violation of the Establishment Clause for the following 3 reasons. First, under the 3-pronged test established in or set forth in the 1971 case of Lemon versus Kurtzman, this ordinance fails to pass the second and third prongs and quite possibly the first prong as well. Second, the 1983 case of Marsh versus Chambers is inapplicable in this scenario. However, should this bench find that Marsh versus Chambers is applicable, then even under Marsh, Your Honors, this ordinance is unconstitutional.
Counselor, would you mind starting there on the theory that Marsh has functioned as an exception to the Lemon test for many, many years, and that therefore the analysis under Marsh might help us more?
Certainly, Your Honor. Well, as a threshold concern, I would just like to point out that regardless of which one of these cases we use as a lens to look at these facts, the outcome would be the same. But as Justice Abraham mentioned earlier, Marsh was decided very narrowly. When this court granted certiorari to listen or to hear the Marsh versus Chambers case, it did so on the narrow issue of the Nebraska state legislature's practice of using paid chaplains to deliver invocational prayers at the beginning of legislative meetings. Moreover, Mr. Ian Wishnick is not challenging the...
I'm sorry. Are you saying that Marsh is distinguishable because state-paid chaplains delivered the prayers there, whereas unpaid citizens deliver the prayers here?
Your Honor, that is one of the reasons it is distinguishable.
Why does
But
that
how
make a
does that
difference?
help you? Yeah. What?
Because, Your Honors, that would lead to the conclusion that Marsh should not be applicable in this scenario because we...
But in Marsh, you may recall, Counselor, that one of the challenges was that government funds were used to pay the clerics who delivered the prayers. And in fact, the district court in Marsh invalidated it not because of the content of the prayer, but because public funds were being used to pay a cleric to deliver the prayer, in that court's view, in violation of the Establishment Clause. So the fact that it was paid clerics was an additional problem in Marsh, not an Establishment Clause, a potential Establishment Clause problem in Marsh, wasn't it? In other words, I don't understand how that distinction helps you.
Because it does not help me, apparently, Your Honors, I would like to retract that previous statement, if that would be okay. But I would then say, however, that what we are challenging here today is an amendment to an ordinance. We aren't challenging the practice of legislative prayers, which under Marsh versus Chambers have been held to be a sui generis category. Legislative prayers are provided throughout this nation in many of our states. And it's the practice itself is not being challenged. What we are challenging is an ordinance regulating that practice. Now, even under Marsh, if you were to apply a Marsh analysis.
Well, I'm not quite sure I follow that. This ordinance says, in effect, we want, for the same historic reasons, they even reference the tradition, the American civic tradition. They say we want a prayer at the start because that's the way legislatures in the American tradition have done their job from time immemorial. And to make it, to deflect even any suggestion that we're favoring one religion over another, anyone can apply to give this prayer, and as long as they don't promote some specific religion and just mention God in the abstract sense, they'll be able to do it. Why isn't that a better case for approval than Marsh?
Your Honors, stated that way, it does sound as though the petitioner has a valid case. However, Justice Weiss had earlier pointed out that this record is replete with several facts which, when taken together and considered with the terms of the ordinance, show that the town is essentially using this ordinance to suppress a minority it does not agree with.
So are you challenging this ordinance only as applied as opposed to facially?
The respondent is challenging this ordinance both on its face as well as in practice.
All right. Well, tell me about the face.
Well, Your Honors, it uses the ordinance requires that invocations be given in the name of God. Now, I think we can all agree that that term God does not encompass polytheism and quite possibly excludes atheists depending on what their views are. Now,
Yeah, conceded, but that was true in Marsh, and that's true every time. 99% of the legislatures will invoke the name God. It's all it's on our currency. It's all over the place.
Your Honor, as I recall, in Marsh versus Chambers, once the suit was filed, references to Jesus Christ were specifically removed by, I believe it was clergyman or chaplain Palmer. What that suggests is that these prayers, if given, are meant to be non-sectarian. That is also how the Fourth Circuit and indeed the 11th Circuit have applied Marsh versus Chambers. If you look at Fourth Circuit cases, all the invocational prayers that have been approved have been non-sectarian.
But haven't they interpreted the use of the word God as non-sectarian? Isn't that what the court has basically said, that is non-sectarian? That to say, in God we trust, or to say, under God in the Pledge of Allegiance, doesn't violate the Establishment Clause because it's a kind of ceremonial deism that encompasses our tradition and history, and it's in some ways considered to be non-sectarian.
Yes, Your Honor, but even if we were to concede that on its face the term God encompasses all religions, or as you have just stated, given the weight of all the facts of this record, it seems clear that what is really going on here is this ordinance is being used against a minority by a majority group.
Supposing that we believe that based on the record here, are you challenging the enforcement of the ordinance or the ordinance on its face? I'm repeating that question because I'm a little confused. The ordinance on its face appears to say that a particular deity may not be invoked. Now, I see in the record that particular deities seem regularly to be invoked, but it does say that that shouldn't happen, and it does say that there should not be a reference to any particular religious tenet. So, my question is the ordinance unconstitutional, or is the ordinance sound under Marsh, and what's unconstitutional is how it's been enforced?
Your Honor, for the sake of argument, respondent will concede that only for the sake of argument, respondent will concede that the ordinance on its face is arguably within the confines of the Establishment Clause. However, given the ordinance in practice, if you look at footnote 7 on page 5 of the record, you see that Daniel Binns was approved, in fact, and was allowed to deliver a clearly sectarian prayer in direct violation of the ordinance in question. Meanwhile, my client, Mr. Ian Wishnick, who submitted a request for a sectarian prayer, was outright denied.
Yes, I see that in the record. May I just ask one more question?
Yes,
in order to invalidate this ordinance on its face, would we have to overrule Marsh?
No, Your Honor, because in Marsh there was no ordinance in question. There wasn't an ordinance regulating the practice of prayers. Here, what we would be saying, if I understand it
didn't Nebraska
correctly,
have a statute calling for prayers and the payment of chaplains to deliver them? Just as Congress had a statute doing that?
Yes, Your Honor. May I have just a quick moment? Admittedly, Your Honor, I do not have an exact question, and I hope you would pardon my inexperience, my relative inexperience to this bench. I'm not certain that that it's necessary for Marsh to be reversed.
Okay.
Is there some way that we could distinguish this case from the facts in Marsh and can you suggest a way, perhaps, that we might be able to uphold Marsh and still find this unconstitutional on its face? Perhaps a closer look at the language itself, what use of the word God, perhaps as we've evolved as a nation, how that word is used in public, if some historical changes have happened.
First of all, Mr. Justice Abraham, I thank you for all those suggestions.
You're welcome.
I'm going to try my best to, in fact, what I would like to stick to, Your Honors, quite frankly, is the record. Now, the petitioners, the town of Imagine has suggested that they are looking for unity, for solemnity, for harmony. Your Honors, if it is tolerance that the town of Imagine is seeking, then I would ask the town to consider the following words as well as this bench. If the two races are to meet upon terms of social equality, it must be the result of natural affinities, a mutual appreciation of each other's merits, and a voluntary consent of individuals. Legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. Now, these are the words of Justice Henry Brown in Plessy versus Ferguson. Now, admittedly, the decision in that case was wrong, but thankfully, this court reversed that decision in 1954 with Brown versus Board of Education. Your Honors, those words are quite relevant and pertinent to this case. Because you see, tolerance is not something that we can legislate. Tolerance is not something that we can compel. Tolerance needs to come from within, Your Honors. And it can only be learned in the free marketplace of ideas, through the sharing of ideas, without the government reaching into the hearts and souls of people where religion resides. And so what I think we have here in this case is essentially a record full of facts that show an impermissible motive, which under Marsh versus Chambers would render this ordinance unconstitutional.
That's certainly not the purpose that in this court, in this argument, your adversaries were saying was the purpose of legislation. They didn't say the purpose of this legislation was to increase tolerance or anything like that. They said the purpose was to impress upon the legislators and the public generally both the fact that all humans are fallible and should not confuse themselves with an infallible being, and secondly, that what the legislature was undertaking was a solemn matter not to be taken up with frivolity. So that may be a legitimate or illegitimate purpose or anything else, but it's not tolerance that they're saying is the purpose of this legislation.
Your Honor, if the town's purpose is solemnity, while they have not explicitly stated the following, consider, if you will, is it reasonable that solemnizing two warring different sects, two different religious sects who are at physical, quite violent at times, war with each other, is it reasonable that prayer of all things, prayer, would bring them together and would solemnize them and create some harmony or unity? Now, given the unreasonableness of this proposition, I think...
Well, I'm sorry, Counselor, are you saying that prayer does not have the power to bring people together?
Your Honor, I'm simply suggesting that when two different religious sects are at war with one another, putting them in the same room and then asking them to deliver prayers...
I see.
It's unlikely that they're going to get along after that. And moreover, I do believe that this ordinance is being used to the advantage of one group over another, as is seen in the facts.
It seems that your argument then is that this court, although it meant well in Marsh versus Chambers, did not fully understand the limits of the word God when it saw that term as a non-sectarian term, and that as our society has become more heterogeneous, perhaps it's time to redefine those terms and ceremonial deism. it seems to be that's what you're putting forward, that the way the court saw it may have been from a limited perspective, not having the benefit of experience that we now have, having a more heterogeneous society. Is that perhaps the way separate but equal seemed to fit and seemed to be constitutional to the Plessy court, but the Brown court saw it differently?
Chief Justice, if I may.
Yes, you may answer.
Justice Abraham, are you asking for my personal opinion or respondent's
Is that
position?
your argument? I'm trying to just pull the threads together and to see if perhaps, you know, what you're suggesting this court do with Marsh versus Chambers.
Your Honor, respondent's position is that the actual practice of legislative prayers is perfectly fine, which I believe is what the Marsh court upheld. What we are dealing with here is an ordinance regulating those prayers in a manner that seems to be inconsistent with the values that the framers of the Constitution intended this nation to be built upon, which is neutrality. If you're going to have legislative prayers, Your Honors, anyone should be able to participate in those prayers. Thank you. I thank you all for your audience.
Thank you. Mr. James, you may have rebuttal.
Your Honors, I'd just like to use this opportunity, or petitioner would like to use this opportunity to just clarify three distinct parts of the record, not to contradict anything that was said, but simply to add additional information for the court's consideration. With regards to the arson committed by one Christopher Costello, petitioner would like to point out that local law enforcement both stopped and incarcerated Mr. Costello and did so again upon the murder in a more permanent sense, in which a local sheriff shot him to death. The second instance, Councilwoman Wine's comments were uttered in a public forum, the same kind as respondents referenced as being beyond the censorship of the town of Imagine. Petitioner does not believe two people may be used to impugn the honor and integrity of a town of thousands. Thank you, Your Honors.
Thank you.
All rise.
Great. That was a great job by all four sides. We're going to take a short break. If you leave the room, I would say please come back as soon as possible. As the judges deliberate, we will resume the ceremony. Thank you.
Well, I remember that, and I tried to keep it in mind, but I got nervous. Yeah.
Ian, real quick, we have to get all the e-boards together, and the new members and the current members, because the photographer has to change them to 4 o'clock, so we need to do group shots now.
We'll do the e-board and then in 5 minutes when everybody comes back. We might not get
pictures. I mean, people have already out of the room. I don't know if everyone's here yet.
Yeah, I mean, we can give 5 minutes. I'm sure people will by that point. We can try like 30 people together. So just announce it now that oh, sorry.
It's okay. Excuse me, everyone. If you're here, you should stay here, actually. Don't take the break because our photographer is leaving in a few minutes, so we want to get pictures of the new members. So I apologize if we told you you have a break. We just want everybody here. All right, thanks.
If you're new, actually, if you're a new member, can you just kind of move to the forefront? So
Let's congregate over.
yes, congregate to the side to my right. As soon as the rest of the members come in, we'll take a big group shot.
I wasn't just saying. I don't just say things to say it. Yeah.
Very well.
Thanks. I got it. I didn't take your own advice.
Why did you get the turnover with less than a minute left?
I don't know. I felt I had to bring up something with council members, and I got nervous, and I just said whatever the hell I could think of that came to my mind, and that was the last part of my roadmap.
You're super aggressive up there.
Oh, yeah.
I don't know if you guys noticed, but you were the only one who was like leaning in.
Yeah, well, that was some...
The judges from us.
But they were listening to me.
Yeah.
So, like, so I feel like... It's because, I'm telling you, once... They were, like, listening, and that's the idea.
They just let you talk.
Yeah.
They did, and I was thinking that. I'm like, I hope that's for them. But I mispronounced her name, by the way. I was like, Abraham. I got flustered. I did have his name, and I got flustered. I don't know. Oh, my God. You know how much if it wasn't for you, I'm serious, dude, I wouldn't even be here. Good job. Thank you. Thank you.
Good. So impressive. But no
Yeah, it's the little things. I owe it to him, by the way. I really do.
You guys were partners?
Yeah, and if it wasn't for him, like, I mean it, like, this guy's, like, dude. Oh, shucks. The good, but there were some things I missed. There were some things I got nervous, but surprised though. I wasn't nervous any other day.
Hey guys, we're gonna try and do a group picture real quick. The photographer has to take off, so we're gonna try and rush this while the judges are deliberating. Can I get everybody kind of up front over here, and we're gonna hopefully squeeze together. Yeah, if you're tall, stand in the back. That includes you, Joe.
You're great. You should be proud.
I am relieved. I'm relieved.
Like you're not going to go back up to
Yeah. Well.
Guys, can we start squeezing back, please?
Does move. Do you need us to move it? Or it should move?
Maybe not. Yeah, they might have. You know what? We can take it with you can take it from the high ground. No, I think it's nicer in here. That's why. Yeah. So how far? You can take it from a higher level, can't you? Yeah.
Well, it pivots.
It's not going to move.
It pivots. Okay, why don't we do this? I'm going to take everybody and put them in these seats back here, and I'm going to stand on the table and shoot down like this. Is that possible?
Yeah, that works. You just stand on the table and shoot down?
Or, you know what, let me just try something here. Can I stand on this table here?
Yeah, that's fine.
This is for the new guys or everybody?
For everybody.
Squeeze in, guys, just a little bit. Yeah, get in. I'm going to get it. Yeah. Joe, get in. We're waiting for Danny.
Not helpful being short.
Is Danny here yet? No. Just give it 1 minute, please.
Okay, sure. We're still going to need to come in a little more. If you guys can tighten it up a little bit more. Just the people on the side. You guys on the sides here, if you can maybe come closer. Yeah, you guys on the side.
Where's Gaurav? Where do I go? I feel good.
There's no way we can move this thing. It's not going to move. All right, we're going to do it like this. Here we go. Everyone looking right up here. Big smile. Everyone try not to blink. We're going to do about 5 shots. Right here, big smile. 1, 2, 3. We're going to do a few more. Right here. Big smile, looking right in the camera. Try not to blink. Look in here. Everyone look here. Don't take your eyes away from the lens. Look here. There you go. That'll do it. That head will get him every time. Thank you.
Do you want to get any of the shots or while he's here? No, right? Do you get any of the shots?
What?
All right.
Were you in the picture or no?
I was in the picture.
Oh, you were?
What?
Were you in this picture?
Yeah.
Oh, good.
It's not his picture. You
I
can't
want
take
to
it. Oh, yeah, right.
Hey, everyone, if you could just quiet down a minute. The 4 finalists, if you can just step up towards the front now.
The 4 finalists?
4 finalists. Let's go, the 4 finalists now. Come on. Judges are on their way back.
Hey, where's the other 2? Randy, guys.
Pay attention, come on.
Let's go.
Our photographer has to leave.
We're just gonna take a picture of you guys.
All right, go that way. Sorry.
He's very good. He's one of the best. He always
I say foil because you know I'm going to wallop the hell out of them. You know I'm going to be blunt. And you know I'm going to be hard. I'm going to meet someone who's supportive and tell me to go wrong.
So it's funny how like all of them pretty much on the side, on the 2
know what's he gonna do.
Robert Johnson actually fought the government. You might say that you like it awful.
Not as much about
He just got voted.
That was the stuff I wanted to get into.
I tell you, we're speaking about transportation.
Excuse me, everyone? Excuse me. Thank you. Please take your seats. The judges are coming. They're coming back in with the decision. I just want to make a quick announcement that for new members and old members and friends and family, we're going to head to M15 afterwards for just some drinks, social banter, whatnot. So right afterwards, I think everyone knows where that is. If not, just follow the crowd. So we'll meet you at M15, and let's just take your seats. Thank you.
Please be seated. Having now participated in this competition, I believe 6 years in a row, I've finally learned the routine, which is that at this juncture we return to the courtroom and we announce the winning advocate. As you all know, we do not decide the case on the merits, but rather we judge, if you will, the oral advocacy that has been presented here during this final round, with a view toward naming a winner, if you will, a top oralist. And that it has been for us over the years, certainly been for me over the years as a participant, a difficult exercise. Frankly, I find it much easier dealing with jurisprudential decisions than I do with decisions having to do with pitting one oralist against another. But the panel has considered the arguments that have been presented here by all four of you, and I would like to announce that Mr. James is the winner. Well done. It sounds like you have some fans here, Mr. James. It's also a part of our procedure, if not our tradition, to turn the matter over to each of the members of the bench for purposes of providing comments to each of you concerning your presentations. All of those comments being intended to offer helpful advice to each of you, comments that point to strengths in the approaches you each took respectively, and also suggestions as to perhaps particular approaches that you may wish to avoid in the future. So in pursuit of that goal, I will turn first to my colleague to the right, Judge Jed Rakoff. Judge Rakoff is a very good friend, but I must tell all of you, he tested that friendship today by bringing up baseball and the Phillies. I'm from Western Pennsylvania. Your hypothetical was not appreciated one bit. In Western Pennsylvania, the Pittsburgh City Council would meet, I'm sure, and pass an ordinance which would call for prayers simply asking for a 500 season, for God's sake. Judge Rakoff?
So I need to beg the forgiveness of Judge Smith. The truth is, I'm a Yankees fan. I am from Philadelphia originally, but I gave it all up because I wanted to root for a truly soulless team that represented the heart of corporate America, and the Yankees seemed to be the right one. So
I think you found it.
I think one of the hardest things as a young law student is to participate in this kind of exercise, and I admire all of your courage in doing so. You really, you put yourself on the line in front of a lot of folks. It's good training, but it's not easy, and so I congratulate all of you in your willingness to undertake this competition and having done so well. I do think, Mr. James, there was a great deal in your presentation that I liked. I liked the forcefulness of your tone. I liked the clarity of your thinking. You responded to questions very directly. There was no hesitancy. This was a very tough problem, and there were, even in the first questions, there was this tension between the more you make it government speech, the more you make it establishment, and I thought you dealt well with that situation. And I really don't have any suggestions for improvement, except I was comparing your red tie with my red tie, and I like mine better. But Ariella, you found yourself in some problems and some difficulty, and that's going to happen. And I've seen it happen to even very experienced lawyers. We all tell each other that the way to give a good argument is to prepare and prepare and prepare, but I'm sure you did that. There's always going to be that question you didn't see coming, or that awkward moment when you're halfway through a point and you suddenly realize that's not the point you want to make. You recovered pretty well, but I think you should maybe consider saying, let me restate that, and going back, and so it's not like you're just saying, well, got that one wrong, but let's move on. I wasn't really articulating as well what I really wanted to say. Let me try it again. But I did like the way that after those awkward moments, you came back and recovered. Your tone was fine. One of the things that is on our list of things to rate is respect for the court. Judge, all of us here consider that the single most important thing, and you showed, everyone showed good training in that regard. Randy, I liked very much the fact that you listened carefully to their argument, and were prepared to, therefore, before you got into the heart of the argument, take on some of their problems. I'm not sure I would have put the order that way. I think I might have first laid out, here's our basic argument, but let me clear the dust then by pointing out some inadequacies. The reason I think it's better to put out your basic argument first, if you have a hot bench like this one, you may never get back to your basic points if you're off on the criticizing theirs. But that's a modest suggestion, because I really like the fact that you did listen to what they were saying. You didn't come in with a canned speech, so to speak. You really were prepared to hear what they said and respond directly to it. Where I thought you got more in trouble was relying too much on citing cases as opposed to principles. It's important to, of course, before the Supreme Court, to be fully familiar with their cases. But the justices are going to bring, and even in a lower court, the judge is going to bring up the case that troubles him or her. And when you rattle off 3 or 4 cases and say the law is clear, maybe he doesn't think it's so clear. You're buying yourself a problem by doing that, which you don't have to buy. What you can do is extract the principle and say the sensible principle is this, and then if the judge says, well, but what about case X, Y, or Z? I don't mean to say you should never cite a case. Of course you have to cite cases, but I don't think I would make that quite the cornerstone of your argument that you did. Newer, is it? You started off extremely strong, very good demeanor, you conveyed, by your very tone that, well, now here is reason and justice come to the rescue to save the day. But then you got, I think, a little, had some difficulty responding to some of the more difficult questions. And again, this is a difficult problem, but you can, in my view, you conceded too much. And everyone's taught this. This really came up with a number of the speakers here. If you should not be afraid to concede a point where you absolutely have no answer for it. You would be foolish not to concede a point like that. But there are many situations where a judge, maybe a judge who already has a leaning one way or the other, or just wants to test the strength of your argument, will come on very strong. And isn't it clear, counsel, that blah, blah, blah. And you should not let that intimidate you. You should think of, no, I don't want to concede that. It's an important part of my argument. My client would have me shot if I conceded that. And so, you know, you may need to, try to come back to it later if you can without seeming to evade the subject. But I think it's a mistake to concede too much, and I thought you fell a little bit into that trap. I did want to say one more thing about Mr. James. I thought your rebuttal was really right on target. The place where your opponents had most hurt you was on the facts, and on their version of the facts, it looked like this city council was really out of control. It was just using it, and that's, of course, a one possible reading of it. So it was so good to not try to cover 20 things on your 1 minute of rebuttal, but just take, here are 2 or 3 facts that they have misconstrued the record or not given the court the entire story. And here, I want to point that out. I thought that was very excellent. So I'm sorry to have taken so long. I thought all of you, though, did a fine job, and I'm so grateful. This is now my 8th year, not in a row, but 8th year here, and it's really a wonderful competition.
Thank you, Judge Rakoff. Justice Weiss, Catherine Weiss, I'm not sure that you've participated on a panel for this competition in the past, but if you have, it was not while I've participated. It was great.
I have not done this here before.
Right,
I have
here.
done it elsewhere.
But as you will see from the very short bio that appears in the program, she has an impressive background, and one that includes constitutional litigation. She also has a qualification that makes her really exquisitely well qualified for this. She's not a real judge, so she was able to bring something of considerable value to the panel. And you noted the kind of powerful and incisive questioning that she brought. So, Justice Weiss, could we hear some comments from you?
Sure. First of all, congratulations to all of you. This really is a scary thing to do. And what I will say is, I remember my first constitutional law argument well, and it was really tough. And so practice like this is painful, but it's also a great thing to do. So I commend you for doing it. And it's probably harder to do it in front of all your friends than just in front of your clients who go away. But so I think you all did a very good job, and so here are my thoughts. Mr. James, I don't have your first names in front of me. I think you did a beautiful job of marshaling both the facts and the law in response, and still responding to questions. That's very hard, right? When you have all of these things in your head that you think you want to say, there's a tendency, I think, to say them without regard to what you're being asked. And you really listened to questions, and you really responded to them, which is a very important thing in appellate advocacy because, right, it's the people up here who have all the marbles. And so I think you did a great job, and I agree that your rebuttal was very strong. So congratulations. And your first name, I'm sorry? Ariella. Ariella, I think that you had a strong beginning, and I think that you got rattled by the aggression of my question. So I will warn you that you will find judges just like that. And so take your time, take a breath and ask yourself what you're being asked and answer it plainly, and you will I think do just fine. You had a lot of law and facts in your head, which is a great thing, and you want to just take long enough to make sure you're giving back the ones you need in answer to the question. And it can be very rattling. I mean, hot benches can be very rattling, and you had a lot of questions coming rapid fire up here. I just would second, you too knew your stuff and had lots of citations and the justices who wrote which opinions in your head. That is an important thing in the Supreme Court. There is a lot of that kind of, as Justice, Holmes said, and you find a lot of that in the Supreme Court. And I think that's a positive thing, but I think you really want to make sure that what you're saying is responsive. There were times when I felt like you were telling me things and it wasn't clear how they related to what you'd been asked. And you want to bring those things together as much as you can. And I think you also had a beautiful manner, right? One of the things that's hard to do as an advocate, particularly if you're passionate about your cases, is to come across as balanced, moderate, approachable. And you seemed like all of those things. It is true that you projected the feeling of, I have justice on my side. I am confident that you were just chill. And that really is an impressive thing in this context. And then I think what happened was that you got caught up in the questions and couldn't quite find your way back out of them, and got stuck a little bit. And that can happen. I mean, that's an experience question. I would also just say to all of you that you guys constructed a problem. I take it this is a student-constructed problem, yeah? You guys constructed a problem that had each of you at war with each other, right? The more you argued that it was a public forum for private speech, right? The less you could argue that it was an Establishment Clause problem. The more you argued that it was an Establishment Clause problem, right? You had this on both teams in both directions. And when you have a problem like that, when your two causes of action are in such tension, I think you want to be really careful to work with each other on how you're going to deal with that tension. Now, I gather that these weren't consistent teams, right? You got jumbled every time. But the tension should have come up before. Did it come up before in your previous rounds? Because it's for a court, all I would say is that one of the things that's really important to do is look at your case from 50,000 feet. Don't stay down there in what are my citations and what are my facts and when you're doing an appellate argument, take a minute. What does your whole case look like? Because you're going to be asked, doesn't this claim contradict that claim right out of the box? So be careful that you've coordinated how you're going to handle that. That's just something I would say to all of you for the going forward.
Thank you very much. Judge Rosenberger, your comments, please.
First of all, I have to tell you that each of you did better in this argument than I did in my first appellate argument after I was a lawyer in the appellate division. That's where I argued for the first time. And each argument that I heard today was an awful lot better than the one I gave very many years ago. The problem which many of you faced had to do with confronting questions. It's very hard to confront questions. You think in advance of what the questions may be, and you prepare the answers for the questions which you anticipate. When you get the question which you don't anticipate, that's where the test really comes in. And you've got to do your best to confront the question squarely and do the best you can. You're never going to be able to meet each question in a way which will satisfy you. So don't be frustrated by that, because it's going to happen. But think about the fact that you will have to meet questions which you don't anticipate. And of course, the best way you can do that is to be very familiar with your record. It's important to be familiar with the cases. Of course, you've got to be familiar with every part of the record. And a couple of you had some difficulties with meeting those questions. So in future, you have to work at it. But going back away from this and to the past, once again, there wasn't a day in 19 years in the appellate division where I did not hear arguments from lawyers who were paid a lot to stand up and argue, whose arguments did not measure up to the arguments I heard here this afternoon. And I congratulate each of you for that.
Thank you, Judge Rosenberger. And now I turn to someone you all know very well, Professor Abraham. I must say that Professor Abraham, I hope she doesn't mind my saying this, has become a good friend after my having done this for 6 years in a row, and I know you all know how fortunate you are to have her as an advisor and a participant in the Froessel. She's very dedicated, as all of you know, and has great concern for all of you and for the development of your own oral advocacy skills. And I'm delighted to ask her to make some comments about what she has seen and heard here this afternoon.
Thank you, Judge Smith, and thank you to all of the judges up here on the panel. I think we're all really fortunate to have had them take their time, private time on a Sunday, to come here and listen and participate and give you feedback, and their feedback has been really instructive and helpful. So I just want to really let them know how much we appreciate their participating with us today. It's really so important for the students, and I know everyone appreciates all of your participation. I don't have much to add to what you've heard so far. I know, believe me, I know how hard it is to get up there and argue. And even though I've argued many, many times before many appellate courts, I still get nervous. I still have the butterflies, when I start, at least until the questions start, and then I focus. And sometimes after the questions start, everybody gets in situations that are difficult. I want to really just emphasize, all of you clearly had done a lot of work on, researching the law, remembering which case was which, and all of these concepts are very, very difficult, especially for those of you, most of you I assume, who haven't had con law yet or are taking it right now and had to teach yourself this law, which is very complex and, very confusing, even for those who have had con law, since I understand most of these First Amendment issues aren't even covered in the basic con law course that you're taking, so it doesn't even help. So I know how complicated it is. But I do want to reiterate what's been said about when you're an advocate, first you have to know the record inside and out. And then you've got to know the law inside and out. And then you have to remember that when you come to court, it's a conversation with the court. So when you're asked a question, rather than just respond with a case, you have to actually think about the question and answer the question. And you have to remember that you should have the confidence to do that and not just say, what case says this, but what I'm thinking about it, even if I don't know a case, even if I don't remember the case, I can answer this question, just relying on my common sense and my intelligence and my familiarity with the issues. So sometimes what you have to do to be able to listen is to not keep reciting all of the cases and the holdings in your head, but just put them down for a minute and think about the issues. And as Judge Weiss said, take the long view. Look at it from far away. And remember what are the important principles here and what should be the answer. And then if I can come up with a case to support me, that's great. But if I can't, I can still have the back and forth with the court, because remember, the Supreme Court is not bound by much, right? So if you can be persuasive, talking about the issues and the principles, that's really important. And you've got to do that first. And then you rely on authority to support that. But don't just jump to the authority without thinking through what the principle is that you're trying to make. And so you'll all learn this. It comes with experience. To do what you did is much more than I could have done when I was in law school. And it takes arguing many, many times and watching arguments and listening to arguments and practicing to be able to do it. But you just need to remember that you need to take the big view and think about what the broad principles are, and then what the small principles are, and then how everything interacts and works with each other. And just as first-year law students sometimes have trouble arguing both sides of the case because they want to say which side should win, and then they think about, well, if I talk about the other side, it's going to be poking holes in my argument. I don't want to do that, and then I won't look like I'm very smart. That's how you prepare for appellate argument. You poke those holes mercilessly in your own argument. You have the person on the other side just destroy your argument. Don't be afraid of those questions. Don't say, well, I'm not going to think about that because I don't know the answer, and that one's really hard. But rather, how would someone destroy my argument? And then how am I going to respond to that? And that's really what you do with appellate argument. That's how you really prepare. And it's hard and it's scary because it's the hard questions that you really need to prepare for. And it comes with practice. And you can all do it. Everybody can do it. It's a question of really doing the research, putting in the time, and thinking through the strongest arguments. You've all done really well, and I would also reiterate about the rebuttal. I thought it was great. It was really narrow. That's what rebuttal's for. I would make one tiny suggestion, which is it was really good to state those facts, to clarify something, but then I might have tied it up a little bit more with a conclusory sentence that said, and for these reasons, it's not really fair to argue that the town of Imagine was being this or that. I would just kind of just finish off your facts with a little bit of a punchy, persuasive sentence and then sit down. But that's a very small point. I think what you did in rebuttal is hard, and what you should do, and the tendency is to try to do too much in rebuttal. And that's usually not very effective. So I want to congratulate everybody, and everybody who felt, each of you, as you sort of got mired in difficulty, you came back and you stood up there and responded to questions, and that's really tough to do, and I admire all of you. So congratulations, it's over.
Well, it's not completely over, but I have very little to say. I'm not going to make specific comments about any of the arguments, and the several comments I will make may be, unfortunately, a bit redundant to what you've already heard. I've been a judge on a number of courts now for, I think, what will soon be 27 years. Only 9 of that has been on the Court of Appeals. And I'm going to admit something to all of you that I don't think I've actually ever admitted to anyone, and that is I get nervous as a judge going into a sitting just because we gear so heavily in our preparation and our process toward oral argument that I want to know so much about each case and to be prepared to meet the advocate's arguments with appropriate questions that, quite frankly, I go into at least some of them, and many times myself, nervous. It's a natural response for an advocate. I'm not sure it's a natural response for a judge, so I'm actually sorry I admitted that now, but it is a very intense process, as you've discovered throughout your competition and today, into which you pour yourself for a very, very limited period of time. And we're controlling to such a great extent the way you're using that time, at least if you have a hot court, a hot panel. And probably the best piece of advice that you can be given, and you've actually heard it perhaps in different words from a few people here this afternoon, and that is to try to be flexible. Don't forget that as much as I try to prepare going into oral argument to hear your case presented by you and your adversary, you still know it better than I do and the other members of the panel I'm sitting with now. If you've done just a modicum of your homework, and you will have done more than that, you know your case better than the judge or judges are going to know it. So have confidence in that. And then in entering that courtroom, try, as hard as it may be, but try to relax in the sense that because I know this case better than any of those folks know it, I'm going to stand here and I'm going to be prepared to answer each question as best I can, based on my knowledge of the legal principles, the jurisprudence that applies in this case, and based on my knowledge of the record. And as you've also heard, know that record. You may not know, you probably won't know cites to specific pages in it, but know it's there. Know how to get there. And simply respond to questions. Don't make a practice of telling the panel necessarily what you want them to hear. Oh, yes, you have a theme, a message. You have an argument to make that you want to get across, that you want the panel to hear. But don't attempt that at the expense of not directly answering the question that has been posed to you by a member of the panel. It's very, very aggravating to an appellate panel, to any judge, to have an advocate be less than responsive to the question that has been posed, and you proceed at your own risk and probably do your cause damage, because recognize that in that compact little bit of time that you have to present that argument, your job is to persuade, and I'm asking you those questions because I want an answer to them. So it's important you tell me what you think I want to hear about. Not as important that you tell me what you want to say in some rote fashion. Again, a number of you, all of you, I have no doubt, were very nervous. Nobody here, however, no matter how nervous they were, resorted to an approach taken by a good friend of mine a number of years ago, not too many years ago, with our court. I had worked with my friend George years and years ago on an intense several-year investigation into organized crime. We were prosecutors, and there were only two of us working this investigation, and I got to know him very well. He was not an appellate lawyer. I, at that time, had no real appellate experience either. So flash forward many years, and just a few years ago, my friend George appeared before a panel of our court. I wasn't on that panel, but my then Chief Judge, Judge Sirica, who is a very highly respected nationally member of the federal judiciary, was presiding. He's a rather quiet sort. He asks good questions, not a lot of them, and he does so in a quiet manner. But the other two members of the panel made it a very hot panel, peppering the advocates, including my friend George, with many questions. Now, unfortunately, George had stepped in at the last minute on this case. He didn't know the case particularly well. He also didn't have a background in appellate advocacy. And as he was hammered by the other two members of the panel with these probing, difficult questions, he finally looked up to Judge Sirica and using a practice I wouldn't recommend for any of you. He said, Judge Sirica, may I ask a question? Now, most appellate judges would immediately respond, no, our job is to ask the questions, you answer them. But Judge Sirica, in his low-key way, said yes. And my friend George said, could I be doing any worse here? Nobody resorted to that, and nor do I recommend it. You all did a great job of standing up to the questions that were asked. You all demonstrated in your own ways the enormous preparation that you had put into this day, and I commend you for that. So I wanted only to make those general statements, save for one substantive comment, which I'll leave you with. Mr. James, I like your red tie a hell of a lot better than Ray Cobb's. I want you to know that.
This is war.
If you guys want to sit tight for about 5 minutes, we're going to hand out awards for Best Brief, for Respondent, Best Brief for Petitioner. I think Mr. James has an award coming his way. And Best Preliminary Round Oral Advocate, Best Team, and I think that's it. But so if you guys can hang tight for a few minutes, we'll get to that right away.
Christopher Benz. Benz.
Christopher Benz. Christopher Benz.
For the fourth time, Christopher Benz, please join us over here. Yes.
Eat those.
One round per item of food.
Judicial water. That was cute. You guys said that.
You and the rest of the
Okay, this is the best part. We're going to do awards. Okay, everybody ready? In anticipation, waiting, excited to go home soon or go to M15? Okay, first, best final round advocate, Matthew James. Congratulations. You're welcome. Next, best team, Alex Silverman and Randy Kleinman. Congratulations. Congratulations. Good job. Next, best petitioner brief, Alex Silverman and Randy Kleinman. Congratulations again, best petitioner brief. You're welcome. Yes. Make a space on your wall for those. Best respondent brief, Robert Schibetti. Congratulations. You're welcome.
Congratulations.
And last, best preliminary round oralist, Robert Schibetti. Excuse me. And that's all. So hold on, we're going to be introducing the new members now.
All right. And if you could just hold the applause till the end so we can hear out who I'm calling. We're going to introduce the 2011-2012 new moot court team. Introducing first, Vikram Arneja. Come on up. Next, Adia Balmik. Catherine Blackmer. Jeffrey Blue. Lucy Barazin. Oh, I'm sorry. Oh, okay, I'm sorry. Vanessa Crivero. Elena Fast. Mark Ferguson. Connie Ann Gibalero. Neil Giovannotti. Christina Grulon. Sarah Hansel. Benjamin Humphreys. Noor Mustafa Jalal. Matthew James. Already up there, yay. William Kleindeist. Randy Kleinman. Already up there. Stacy Large. Anibal Luque. Robert Massey. Chloe Mentar. Bindu Nair. Zach Nathanson. Teresa Neri. Amit Patel. Trevor Prince. Jessica Richardson. Robert Scabetti. Jason Sender. Alex Silverman. Arielis Batalnik. Kevin Simpson. Caitlin Tooker. Gabrielle Benito. Mark Wheeler. And last but certainly not least, Melissa Ziegler. Ladies and gentlemen, the 2011-2012 Moot Court team. Woo! Now who wants a drink at M15? Make some noise. Yes, let's. I need one, so.